You have to be a read and video visit with someone that the court ordered you to not have contact with. I recognize that you can't get Miss Brittany off your mind. I recognize that. You know how I recognize that? Because you got it tattooed on your head right now. I think you think you're above the law. I think you can do what you want.
I've seen multiple people fire lawyers and get me.
Okay. Well, you can't. Mister, I got Brittany tattooed on my mind. Excuse me? Pardon? I can't hear you. Because I guarantee you, I will run it up in here. I will charge each one of them individually.
I got something to say.
I don't want to hear it. Bye.
In preparing for today's examination, I discovered that the defendant had called the victim between that original hearing and today. Hold on, it changed because he called her 7 more times last night. 240 calls, 66 pages of messages, and more video visits than I had the time or will to count yesterday. I forwarded these over to Mr. Kaplan and I said, this is what I have, because just based on the e-messages, it's lots of manipulation. I love you so much. When I get out, I'm going to be able to take care of us and our baby. And I'm facing 7 life sentences and this is so terrible. Things like that, that traditionally influence a victim to not testify and to remain on his side. And that was just from the e-messages, because those are far easier to scan through than calls and video visits. I also offered...
This is crazy.
Yep. I also offered...
You have to be a reader to be in jail and video visit with someone that the court ordered you in 2 files not to have contact with. And Mr. Willie Green, no Lee, is not a reader. Are you?
I offered to waive the examinations up because Mr. Green is on dead time. So adjournments are not in his favor because he's on a parole hold. So I offered to waive these up today. So they're up to the circuit court faster. And it's my understanding he wants to run the examination. So prepared to run it, wait for an officer to get here, had another officer call him.
Witness interference and bond violation.
Correct, Your Honor. P53s as well. Able to get a hold of the officer. To his credit, he was upfront with me that he forgot that he had court today. He didn't say he was sick. He didn't say there was an issue with the subpoena. I asked him point blank. He said, no, I'm pretty sure I got it. And I just screwed up. So my officer is not here because of that. But the other thing I want to make the court aware of is that this is not the first time Mr. Green has done this, because when I went to save these e-messages to my computer, it said I already had a file under that name. Because when I last had Mr. Green in 2023 for other felony domestic cases with the same victim, he did the exact same thing back then, where he was calling her and messaging her and using other inmate accounts over and over and over again. So he knows he's not supposed to.
Sorry?
Also, he said I used other people last time. Saying on record,
I don't want you to say anything, because anything you say is on the record. That's exactly what I want you to say. I don't want you saying anything that's going to hurt the case.
So he knows not only he's not supposed to do this, he knows that I, Adam Pfeiffer, the prosecutor, look into these because I was his prosecutor last time.
The whole jail should know that Adam Pfeiffer is going to... I don't understand why it's not well known.
So because of that, Your Honor, I'm asking for an adjournment in these matters.
And so you're subject to the penalty for contempt of court for each violation. Do you understand that? It's up to 93 days in jail and up to $7,500 in fines. Do you understand that, sir? Are you trying to gather understanding, or are you just maintaining? No, I asked, did you understand that the contempt of court procedure? So I'm going to assume you're entering a plea of not guilty as to these violations. So the court will have these set out. We're talking about domestic violence third in both files. We're talking about assault with deadly weapons, assault with intent to do great bodily harm, less than murder or by strangulation, and then interfering with the alleged victim's ability to make a crime report, to which your client is being charged with an habitual offender 4th offense notice. So this is a pattern of behavior that's being reflected here. The victim alleged in this matter, Ms. Brittany Bukowski, this is not the first time she's been a victim. She was also the victim in, I'm assuming, the conviction from 2023, or maybe another case that was charged in 2023. And then there's allegations of video calls and other communication while you're in the custody of the jail after being arraigned on this matter, engaging in activity or communication that would manipulate and or cause her not to want to be a willing participant in the prosecution of this case. You have something you want to share?
Saying I love her is.
Your Honor,
You said you loved her. No, saying you love her doesn't. It's not manipulation. Saying you love her, though, is an admission that you had a communication with her that you weren't supposed to have.
Your Honor, I just want to say if my client chooses to speak, he's doing it against my rights.
You've advised him multiple times on this record, but he is like he's willing to admit to the violations. I recognize that you can't get Miss Brittany off your mind. I recognize that. You know how I recognize that? Because you got it tattooed on your head right now. But there's a court order. Do you know what a court order means? Or are you above the law? I think you think you're above the law. I think you can do what you want. Someone tells you you can't have contact, and you think that because I tell her I love her, that doesn't count. And to the contrary, I think the allegations are that you did more than just tell her that you love her. But you don't get to communicate with a person that the court told you can't communicate with because you have already allegedly assaulted her with intent to do great bodily harm, less than murder or by strangulation. In 2 separate files, you have a domestic violence third and another time where you allegedly assaulted her with a deadly weapon. You don't get to communicate with her to tell her you love her. You don't get to do that. Okay? Unfortunately, English is my only language. I don't know any other languages I can communicate this to you in. But there's no contact between you and Miss Brittany. And to ensure that, I'm going to suspend all of your communication privileges while you're in the custody of the jail. You will only be able to communicate with Mr. Kaplan. You can fire whoever you want and hire an attorney yourself or represent yourself. That's your right. You don't get to get a different public defender. Did you recognize that?
Everybody else, I don't.
I don't know what you're talking about. You don't get to select which public defender you're going to get. Mr. Kaplan is already conflict counsel, correct?
No.
Oh, were you?
There is no conflict counsel.
Oh, you hired him.
No, I'm public defender.
Oh, I didn't know you were at the public defender's office. Okay, very good. And so you don't get to select which public defender you get. No, that's not how it works. You don't get to decide that I don't want this one, I get another one. That's not how this works. And Mr. Kaplan was assigned to represent you in this matter. If you don't like his representation.
He's not representing. He just showed up at court. I don't got no police report. I don't even know what I'm in here for. I don't even know what I'm eligible.
You don't know what you're in here for. You've been arraigned.
I don't know nothing. I have no police report, nothing. I don't even know what's going on.
You're requesting to meet with him to go over the discovery. You can fire him, but then you have to hire your own attorney. That's not how the public defender's office works. You don't get to just swap out and you get another public defender.
I've seen multiple people fire lawyers and get me.
Okay. Well, you can't. Any other questions about that?
I will make sure he gets discovery in jail. It may take some time, but we'll have.
Well, it sounds like there's additional discovery coming in. Right. Your attorney and the prosecutor has already represented on this record that at your last court date, they were both in the same trial. So that's probably why you were not able to meet with your attorney to go over discovery. But you were busy allegedly making phone calls talking about your love. Anyways. Excuse me? Pardon? I can't hear you.
There's nobody in here. There's no police, no victims. Y'all keep postponing my court dates.
Who's y'all? Y'all keep postponing. I ain't y'all. That's number one. My name is Judge Simmons to you, or you can call me Your Honor. The other thing is the only reason why this case was postponed previously is because the attorneys were in trial.
That's only a week or 60 days.
Says who? You decided to how long someone else's trial was going to go, and you decided how long I had on my docket or when I was going to be available. You decided that. Why don't you work on deciding how you're going to control your own actions first, Mr. I got Brittany tattooed on my mind. Okay, decide that you're going to be in compliance with court orders so that you don't get a contempt of court, because I guarantee you I will run it up in here. I will charge each one of them individually, and you will get 93 days on each and every phone call. Do you understand that? Your phone privileges are suspended pending a hearing on the violations. Discovery will be turned over to your attorney. Your attorney will meet with you.
Thank you, Your Honor.
Any additional matters for the record?
Not from the defense, Your Honor.
None from the
I
people.
got something to say.
I don't want to hear it. Bye.
Just you want to smart about it.
We're running somebody. Or
Oh.
LaPera.
What did you say? That what is crazy?
Excuse me?
No, what did you say? That what is, yes, you did. You said that what is crazy?
What did you say?
What did you say though? That what is crazy? You have added it to that. You don't run this. I'll take you down what you tell me to take you down. Let's go.